exactly where you have put it.
With me here tonight on the stage is none other than Dr. Benson Tusasirwe from Makerere University School of Law. Dr. Benson, he is an expert on constitutional law. But as we speak now, Uganda as a country is being faced with a serious legal question, as the opposition now consider going to court to challenge the outcomes of the 2016 presidential polls. Now, we are being joined by Dr. Benson to discuss some of these controversial issues that bring to the fore some issues to do with law. Thanks for joining me, Dr. Benson.
Thank you.
Do you think that the opposition has a good case against the ruling NRM?
I also think they have a good case on just the sheer mathematics. If you went back to those boxes, chances are that you wouldn't find some of the votes there. I also think that you are likely to find situations where what was on the declaration of results forms, the DR forms, given in hard copy to the candidates' agents, is not what is tabulated in the breakdown which was distributed by the Electoral Commission. Both are possible. And if I were the one, I would go for the bigger one, which challenges the whole process.
Given Uganda's past electoral cases, in this very case, what is the legal technicality there?
Legal technicality is, did the results which were announced reflect what actually the people did, the true will of the people? That is the technical thing. Now, how do you determine the will? By looking at whether these are the votes they cast, so the tallying. But two, whether they were given the opportunity to express their will. That's the second question. You could look at both of those. Now, all that you are supposed to prepare and present in a court in 10 days. That's the legal challenge.
Some of your fellow land colleagues are looking at is the question of the continued detention of opposition leader. That in this case he was the flag bearer over the FDC, who is supposed to adduce some of the evidence he's talking about, but he continues being detained in his house. Are you not seeing this as also a legal technicality, because he's supposed to produce the declaration form result?
From the human rights point of view, you are saying continuously that he is not under arrest. But if a person is not under arrest and yet he cannot move as he wishes, what is that? Arrest in legal terms is the preventing of a person from movement. So that's it. But coming to the election question, the technicality of detaining a person who is supposed to be out putting together a case, yes, that's a very serious technicality. In fact, at the best of times when we are free to move, it is almost impossible to put together a presidential petition in 10 days when you cannot even move out of your house. To me, it's impossible. I read somewhere, I think today, that Fred Mpanga, Mr. Mpanga, David Mpanga, one of his usual lawyers, is thinking of not representing him. And if I were in his place, perhaps I would feel the same way.
Don't you think that that is already a weakness in the entire setup of this case?
Yes.
Because if you are having your own lawyers now, considering to pull out of the case, and you are having another lawyer of yours who's Apollon Sibambi, whose house is under siege.
It is a serious technical problem. Of course, it must be deliberate, that you have a limited time, 10 days, and that law is worded in mandatory terms, shall be filed within 10 days. And within those 10 days, you cannot contact your lawyers. The lawyers themselves are heavily inconvenienced as a way of making them despondent and giving up. But it goes beyond that. It is a very serious affront to constitutionalism and the rule of law in this country. Because every Ugandan has a right to access justice unrestrained. By the way, even when you are in jail, you have a right to reasonably have audience with your lawyers. Now he is not being given that.
The kind of judiciary you have, because all these are unfolding in the face of the judiciary.
Yes.
But it's squared.
Yes. Actually, I wouldn't blame the judiciary, incidentally. Do you know why? I wouldn't blame the judiciary because the legal culture we operate under, which is a leftover of colonial legal practice, is that a court of law cannot, on its own, cannot move itself to enter into a matter. Someone must move it. I have not heard of any application for habeas corpus or any application for any orders which has been filed in a court of law by Besigye, Dr. Besigye and his supporters, seeking a declaration that he is being treated unlawfully.
When you look at the composition of the Supreme Court, where this case is supposed to be heard, do you think that the opposition should expect fair justice there, given what now an assessment is coming out that about 95 or 5% of the judges sitting on the panel of that Supreme Court are cadre judges, with the exception of one or two?
That's a very unfair question to ask a lawyer. As a professional, as a lawyer, I'm also in legal practice, incidentally, and as a teacher of law, I cannot say there is anything like a cadre judge. And by the way, what you call cadre judges can shock you. I can give you one example, since he's no longer in that court. You can use names. Retired Justice Dr. Kanyihamba, professor, was an attorney general in NRM, in government, in Museveni's government. He was a presidential advisor. He was brought back from UK by Museveni. He has written saying President Museveni is his personal friend. But in the 2006 petition, he decided against President Museveni.
The decision of 2006 has explained the volume of misfortunes that have played in his face ever since he took that decision. Of course,
Yes.
it built his momentum.
Yes.
It kept his credibility.
Yes.
And those who never wanted to stand for the truth he stood for, they have also got their share of public judgment.
I would not, if I was Dr. Besigye, I would not hesitate to file the case because of the perception that they are cadre judges. Because for a judge, if the evidence is clear and overwhelming, he will have to decide in your favor. There are things they do, yes. They can be subjected to some pressure. But depending on the weight of evidence, one, you can be sure that at some point, even the most devoted cadre of cadres will say, beyond this, we cannot die.
Of course, in the course of this interactive news segment, we shall be playing that bite of where President Museveni says that whoever will want to go to court to dispute 2016 presidential results that were announced by none other than Dr. Badu Chigundu, the chairman of the Electoral Commission, is wasting his time.
Anybody who is trying to challenge the results of this election must not be serious. This is because if NRM was rigging, why did we not rig in Kampala? Why do I agree to lose where I can rig? That's rubbish.
Doesn't that already cast,
Already prejudged
it does.
judgment
Yes.
on the kind of judiciary that we have. You know, he is the appointing authority, and
Yes.
how these people are appointed in those positions of judges.
I agree with you to some extent, but only to some extent. Of course, the fact that he is the appointing authority creates a problem when you are petitioning against him. But we know how many times government has lost cases, including cases in which the appointing authority had a direct interest. The same Makerere chain of cases, for example, including one in which the referendum of is it 2000 or 2002, was declared void and unconstitutional.
Now, with the stalemate that is playing out, where the key witness, who's Dr. Kizza Besigye, who's supposed to adduce evidence in regard to electoral malpractices, is still held under communicado in his own home. We would like to know from you, does court have the jurisdiction, even though this has played out, but it can still offer a leeway for him to say that much as the deadline has elapsed, but out of the wisdom of the court, we feel that you can still...
Section 59 of the Presidential Elections Act is the law under which those petitions are filed. And it says the petition shall be filed within 10 days from the time when the results were declared. And when the law, of course, uses shall, we take it that ordinarily it's mandatory. So yes, in a general, there would be that would be it after 10 days. It's impossible. But
can it be bent? Can the law
yes,
be bent now in this
in law, courts have what we call inherent powers to do things to meet the ends of justice. And one of those powers is the inherent power to extend the time fixed by law. When the time is fixed by law, courts have inherent power to extend it for good cause.
Well, thanks, Dr. Benson, for joining us on this interactive news segment where we discuss issues that affect the people.
Thank you.
Thank you very much.
Thank you, Timothy.